Hello and welcome दोस्तों. Today we will see one of the most important article, that is article 136. This article is one of those articles which are important with respect to the power of Supreme Court. So if you want to understand the power of Supreme Court, you must understand the article 136, article 141, article 142, article 32, right, article 137. So these are the articles which have immense bearing on Supreme Court's power, right? So in that line we are discussing article 136 today. So what does article 136 talks about? So article 136 talks about giving a power of Supreme Court to grant special leave. So power of Supreme Court to grant special leave. Special leave means special permission. Remember this, special permission. Against what? Special permission against what? The special permission against any judgment of any court or any tribunal, right? So if you are not satisfied with any court or any judgment of any court, then you can file special petition in Supreme Court that you are not satisfied with judgment of these courts. Then Supreme Court has a discretionary power to allow you or disallow you. They can take your case or they can reject your case based on the merits of case, right? So they see if there is a question of law, there is a miscarriage of justice, or there is error in law or in the judgment given by the High Court or any court in the India for that matter. So in this case, Supreme Court can allow you to go against the judgment of these courts, right? So it says that Supreme Court has the power to grant special leave to appeal against any judgment, any order, any decree made by any court, tribunal in India. So this is a discretionary power. So discretionary power means they can take your case or they can reject your case. So that is the discretionary power. So in this article there is clause 2. So clause 2 says that this power lies against normal court and tribunal. So this power does not lie against court martial or military courts. So that was the all about article 136. So now let us see some examples where this article has application, right? So let me see you. Let me show you. So special leave petition, so that is issued under article 136. So you can use article 136 and file special leave petition in a Supreme Court. So only Supreme Court can take special leave petition. Remember this, only Supreme Court has the jurisdiction to review, jurisdiction to take your special leave petitions. So special leave petition, what they say? So what they say, they allow you to file your case in Supreme Court against order of any court, right? So and it is issued against article 136. So you might have heard about the PIL, right? The public interest litigation. Do you know under which article PIL is issued? So PIL issued against article 32, that is right to constitutional remedy, right? Do you know under which article review petition is filed? So review petition is filed under article 137. So remember this. Now let us understand what are the key aspects of special leave petitions. So jurisdiction, first of all, it is a jurisdiction of Supreme Court to hear your special leave. Again, grounds of filing, Supreme Court will see if there is a merit in your case. They will see if there is a substantial question of law of general importance. If they will see if there is error of law. If they see that there is a miscarriage of justice is done in the judgment, right, then only they will take your case. So it is a discretionary power of Supreme Court to take your case or not, right? So there is a limitation period that you have to file SLP within 90 days, right? Within 90 days. After that, only under exceptional case, only Supreme Court will hear your case, right? So that is the limitation period. Then there is a filing requirement that you must file that SLP through advocate on record in Supreme Court. So if Supreme Court decides to admit your case, then they will issue notice to the respondents and start your case, right? So what are the example of this case is that there was a case of Lalita Kumari versus government of Uttar Pradesh, where police failed to file FIR So there was a case of gang rape. So gang rape is a serious cognizable offense, but police did not file FIR. So Lalita Kumari went to Supreme Court through Article 136 special leave petition. So Supreme Court is let us understand what was the background of this case. That she was trying to file a case. So but police were not taking that case. They were not filing the FIR. So against this inaction of police, she filed petition. So issue is that whether police is obligated to file an FIR, or police can have discretion to conduct preliminary inquiry. So what police generally do, they conduct preliminary inquiry and then they file FIR. So court was considering that if under cognizable cases, if the case is cognizable. What does cognizable case means? Cognizable case means a serious offense such as murder, injury, such as dowry, death. So such kind of criminal or serious cases are come under cognizable cases. So there was an issue that if there is cognizable offense, should police conduct preliminary inquiry or should they directly file FIR? So court considered this case and they found that under section 154 of the CRPC, police should immediately file FIR before even conducting the preliminary inquiry, right? So this was done because if they wait for the conducting preliminary inquiry, then there is a chances that chances of loss of evidence, right? Chances of manipulation of witnesses, right? So in order to avoid this, police should directly, first of all, police should not wait for the preliminary inquiry, but they file FIR. So no preliminary required under cognizable cases. However, there are exceptions under cognizable cases such as matrimonial dispute, commercial offences, and medical negligence case or corruption cases. So these are also cognizable cases. But under these cognizable cases, police can conduct preliminary inquiry. So Supreme Court issued guidelines under Article 136 that FIR be immediately filed without preliminary inquiry. So in this case, court clarified that legal position regarding the mandatory registration of FIR in cognizable offences and sought to prevent the misuse of police discretion, right? So again, there was Article 262, which talks about the power of Parliament to prevent any court, neither Supreme Court nor any other court shall exercise jurisdiction with respect to the dispute regarding the interstate water dispute. So if there is an interstate water dispute and if there is a tribunal, so judgment of this tribunal cannot be challenged in Supreme Court, right? So under Article 262. So if under Article 262, if any judgment is given by any tribunal, cannot be challenged in Supreme Court. But in 2007, Tamil Nadu filed special leave petition in Supreme Court regarding the Cauvery Water Tribunal against the judgment of Cauvery Water Tribunal, and Supreme Court admitted that, right? So see how that is the power of Supreme Court under Article 136. So under Article 136, Supreme Court can grant anyone to file a petition against any judgment, right? So I hope you guys have understood something out of this video lecture, right? And if this lecture has any way helped you, please like and subscribe and do comment, right? So your every like and every subscription is a token of appreciation to me, and I really appreciate your like and your subscription, right? So thank you.